Now let me turn to the Irish case law as it developed in Ireland some 130 years later. The seminal case is a case called Cook versus Cara, where a servant girl accused the defendant farmer, who was her employer, of being the father of her unborn child. The defendant farmer went to the parish priest when the accusation was levelled at him. And the parish priest got into his motor car, drove out to the young girl's house, bundled her into the car, and brought her back to the presbytery, where he had a confrontation. The law report doesn't tell what happened in the presbytery, and he didn't reveal it. But both Professor Lee and I come from the same part of the country where this case took place. And both of us can imagine in 1945, given the power of the parish priest, what went on in the presbytery. I have no doubt that he produced the Bible. I have no doubt he made the girl swear on it. I have no doubt he made the farmer swear on it. In any event, he was unsuccessful in determining the issue. And the girl's parents then commenced a paternity suit against the farmer. And the priest was called to give evidence. He refused to give evidence in the circuit court. The circuit court now, this case happened in a place near Ballybunion. Some of you may never have been to Ballybunion. Those of you that are golfers may know that President Clinton played in Ballybunion. 5 miles from that is Listowel, where I was born. The circuit court case was heard in Listowel when I was 4 years of age. It was dismissed. The priest was called. He refused to give evidence on the confessional sacerdotal privilege. He was fined £10 for contempt, and the case was dismissed. The girl's parents appealed to the High Court on circuit, and the High Court on circuit came to Tralee, where Professor Lee lived. Now, we had this covered from our base. And Gavin Duffy, who was an eminent High Court judge at the time, came down to Tralee to hear it. And it was his decision that provides the precedent which is relevant. When he appeared in the High Court in Tralee, the priest took the oath and he said as follows: I respectfully decline to give evidence. I cannot conscientiously do so because any information I have was given to me as parish priest. When parishioners come to consult the parish priest, what they tell the priest is given on the understanding of secrecy and should not be revealed under any circumstances. Gavin Duffy said that the issue before him related to jurisdictional position of sacerdotal privilege, by which term he meant, and I quote, a legal right for a priest to refuse in a court of law to divulge any confidential communication whatever made to him as a priest. Now, this is wider than confessional privilege. We'll come to that again. Acknowledging, however, that his decision must be confined to the facts before him, he continued, no canon law was cited to me, and I shall determine the issue without reference to the law of the church. Searching for what law might apply, Gavin Duffy examined the common law, and he found, for the purposes of our debate here at the moment, that the common law, the law of England, which prevailed in Ireland up to 1921, did not recognise the privilege, either in confessional or any other way. The Irish judges in Ireland, however, prior to 1921, some of them recognised the confessional privilege, even though it was contrary to the common law of England. And this they did for the very fact of the futility of trying to invade the secrecy of the confessional, and for the thoroughly practical reason that the Catholic Church was too strong in this country. These are Gavin Duffy's words. So you had some of the Irish judges pre-21 following the confessional privilege. This departure by the Irish judges from English authority was neither reasoned nor principled, but was a pragmatic decision which acknowledged the reality of the religious convictions of the vast majority of the population in Ireland. In these circumstances, Gavin Duffy considered that his task was to determine the question on principle and in conformity with the new Constitution of 1937. Starting his analysis on the Constitution, which specifically, he cited Article 44, 1, 2, 3, which specifically recognized the special position of the Holy Catholic, Apostolic and Roman Catholic Church as being the guardian of the faith professed by a great majority of citizens in Ireland. That was in the Constitution. You had that prominence given to the Roman Catholic Church. Many lawyers think it was only a factual description, and it was taken out sometime later. But that was the article he cited. And secondly, he relied on Article 1 of the Constitution, where the Irish nation affirms its right to develop its life, and I quote, in accordance with its own genius and traditions. Words that echo with what Samson said this morning. He noted the jurisprudence in other countries, including, in particular, the developments in the United States and in Newfoundland and Quebec. The source of this information was Wigmore on Evidence, a copy of the 1940 edition which he had, and where such privilege was recognized in these jurisdictions. He continued, in a state where 9 out of every 10 citizens today are Catholics, and on a matter closely touching the religious outlook of the people, it would be intolerable that the common law, as expounded after the Reformation in a Protestant land, should be taken to bind a nation which persistently repudiated the Reformation as heresy. When, as a measure of necessary convenience, we allowed the common law generally to continue in force, we meant to include all the common law in harmony with the national spirit. We never contemplated the maintenance of any construction of the common law affected by the sectarian background. I am concerned with a juristic system of evidence surviving to us from an alien polity, and it is unthinkable that we should have imposed on ourselves in this matter the regrettable preconception of English judges as having here the binding force of law when merely re-echoed by pre-treaty judges in Ireland. Now that was strong judicial stuff, again echoing, I think, the language of Samson. Liberated from the English authority then, he focused on Wigmore and his 4 canons of interpretation, which I needn't elaborate here. But accepting gratefully the jurist's penetrating analysis, Gavin Duffy proceeded to apply the canons to the problem that confronted him, and he had no difficulty in finding, 1, that Father Behan's assertion that the comments made in his house were made on the understanding of secrecy. 2, that the secrecy was essential if there was to be a satisfactory outcome to the meeting, and confidentiality was essential. 3, that the intimate confidence between the parish priest and his parishioners was of a sacred character, which greatly benefited the public, and who, in the judge's view, wishes to preserve and maintain that relationship. And finally, that the public, if consulted, in his view, would value the retention of the privilege in preference to ordering disclosure in such costs. Now, the other interesting point he established, then having established it was a privilege, he found that there was no waiver possible in this situation. The last speaker spoke about a waiver. He felt that the privilege was a tripartite privilege between the parties and himself as priest. And the interest he had was in answering to his canon law and to avoid excommunication, etc. So Cook, therefore, recognized that there was a privilege, a sacerdotal privilege, which was absolute, and that was not capable of being waived by any party to it between a parish priest dealing with his parishioners on a matter of spiritual nature. Now, interestingly, very interestingly in a sense, there was no mention whatsoever about religious freedom in this. Apart from the constitutional provisions already referred to, namely the special position of the Roman Catholic Church in the Constitution, and this general article in Article 1 about the genius, our own genius and traditions, there was no reference made to Article 44(2), which clearly guarantees freedom of the practice of one religion. That article reads as follows: freedom of conscience and the free profession and practice of religions are, subject to public order and morality, guaranteed to every citizen. I am confident that Gavin Duffy never read Phillips, never probably heard of it, although he had Wigmore, so he must have seen it in a footnote. Instead, he just based his decision on Wigmore's rules of evidence, which were general, which were secular. That he did not discover this argument for himself from an independent reading of the Constitution may be explained in part by the fact that Irish lawyers, for reasons I need not dwell on here, did not fully appreciate until the middle 1960s that the Irish Constitution was a legal document, which not only described institutional architecture of the state, but which also gave legal rights to the individual, particularly under the fundamental rights provisions of Article 40 to 44. Rights which subsequently were found to be capable of being pleaded and enforced by the courts against not only the state, but also horizontally against other individuals. In the early days, and certainly in 1945, the new Constitution was seen more as a document which defined and enshrined general political and social values of an aspirational nature, rather than a document which harboured inside it legal rights that the court would protect. This is all the more interesting, since Gavin Duffy himself acted as an unofficial advisor to De Valera when the Constitution was being drafted in 1937. If one pauses for a moment, one can see interesting parallels between Phillips and Cook, and between the advocates of the liberal position in both cases, William Sampson and Gavin Duffy. Both cases arose in a post-colonial situations, and the Protestant discrimination against Catholics in Ireland was a feature to the arguments relied on by both parties. Furthermore, both Sampson and Gavin Duffy had been active in Irish politics at turbulent periods, albeit a century apart. Gavin Duffy was on the legal team that represented Roderick Casement unsuccessfully in London in 1917, something that affected him deeply. And we've heard from Professor Walsh how the representation at trials affected Sampson. Gavin Duffy was elected to the Dáil in the Sinn Féin landslide election of 1918. A reluctant signatory to the treaty, he was the last to sign it, I understand. He was appointed for a brief period as Minister for Foreign Affairs before being appointed to the bench in 1936. A strong nationalist and a strong Catholic, many of his decisions reflect the nationalist Catholic outlook, and his judicial pronouncements sometimes betray a communication style more suited to that of the political campaigner and the passionate pamphleteer that he was earlier in his career. The similarity with Sampson is in this respect striking. In Cook, some of his historic references to the treatment of Irish Catholics at the hands of a foreign polity echo Sampson's unrestrained submissions in Phillips, although I am sure that the learned judge was totally unaware of these submissions. I can give you other quotes, but I'll skip some of them because I'm caught for time. Finally, it is noteworthy that the courts in both Phillips and Cook were not the most prestigious courts in their respective jurisdictions, whose precedents might be compelling because of the court's very status. Cook, while a reserved judgment, was one of the High Court on circuit. And then Phillips was in the General Sessions Court in New York. There were, however, noticeable differences between the two cases in Phillips and Cook. Phillips was concerned with the confessional privilege as such. Cook was related to a wider sacerdotal privilege. Second, although the similarity of language used by Sampson and Gavin Duffy has been noted, Sampson was merely an amicus curiae in Phillips, whereas Gavin Duffy was the judge, the very judge, sitting without a jury. More significantly, however, when Gavin Duffy upheld the privilege, he did so on Wigmore's principles of confidentiality with no explicit reference to the freedom of religion. Phillips, on the other hand, as you know, embraced that concept fully. And finally, the history of the two cases is significant. as we know from earlier speakers, Phillips ran through the country like wildfire. Especially after the Second World War, it took off, and many statutes were passed at that right because of the Holocaust and the appreciation of the human rights. But Cook stood and stands unchallenged in Ireland. That's probably understandable in a Catholic country. It was never found the need for statutes. There's only two other cases that follow Cook. One was a case in 1981, ER versus JR, a family law case. And that case was a case where a priest was a friend of a couple, married couple. And the marriage got into difficulties, and the priest was also a marriage counsellor, so he started counselling the parties. He failed to get an amicable settlement, and he was called to give evidence, and he refused to do so. Cara in the High Court accepted that this should be privileged. Interestingly enough, however, she based her decision not on the constitutional right to free practice of religion. She based it on the article protecting the family in the Constitution. And she said that marriage counselling should be supported because it supports the family protection in the Constitution. She didn't say anything about practicing religion. Having said that, however, she said, and I quote her, "The Constitution guarantees that the state will protect the family. The provision of confidential marriage counselling, which may help a married couple over a difficulty in their marriage, is a protection of the most practical kind for the family and should be fostered." Now, she also relied on Wigmore for tests. Second, she held that the fact that the counsel was a minister for religion added weight to the proposition that the relationship was a confidential one, but she stopped short of saying that it was essential. It should also be pointed out that when she came to hear the case, that article in the Constitution which gave primacy or recognized the Catholic Church as the primacy was repealed and was taken out of the Constitution in deference to the Northern Brethren and the peace movement in 1972. So that was no longer there. And she said that Gavin Duffy, in relying on that article in the first place, was mistaken, and it shouldn't have been denied, relied on. Secondly, as I say, just because the priest happened to be the marriage advisor happened to be a priest, wasn't essential to the case, in her view. Third, she made her clear that she was not limiting her findings to priests of the Catholic Church when she said, "When I've referred to priest, I am including ministers of religion in general." And fourthly, she emphatically said that the privilege was that of the husband and wife and not of the advisor. So in that situation, she held that they could waive it. So the position then, to summarize the position in Ireland, we have confessional privilege in its full, never challenged since it wasn't that issue in Cook, but was assumed. And Geoghegan, in a later case in 1999, said it was sui juris. So that's a cast in iron, the privileged confession, and the non-waiver of it. With regard to other relationships, if they comply with Wigmore's 4 canons, they may be privileged, but in that situation, the waiver may be waived. There may be a waiver in the position. Now, if we just look for a moment at what are the policy reasons behind this, there has been some reference to it. There are 6 or 7. First of all, there is the fundamental need that's perceived for individuals in society to be able to access a priest or a spiritual advisor for spiritual comfort and succor. Secondly, there's the right of privacy. Thirdly, it is argued that the abolition of the confessional privilege would admit evidence which is analogous to evidence, including confessional evidence, secured by duress and inducement. And that's excluded in evidence anyway, as being badly sought, and it would encourage bad practices in investigation cases. If you can beat a confession out of a fella, why would you go to the bother of engaging in all this forensic investigation? Fourthly, as has been referred here, it is analogous to the legal privilege which exists between a lawyer and a client. Fifthly, given the resolve of the Roman Catholic priest to resist it, if you insisted on divulging this information, you will be confronting and have a confrontational situation where the priests say they will die rather than reveal it. So that's not a very attractive scene for any government. Fifthly, the next one is if the confessional privilege was not recognized or it was abolished, then the sacrament of the institution of confession would go into decline to the detriment of society in general. This is the point that was mentioned already. And it's been questioned, of course. But the argument is that if a fellow or a girl or a woman decides that she will repent and goes to a priest and makes the effort to go to a priest and makes a resolution she won't or he won't sin again, they probably are less likely to sin than a person who wouldn't do it. Moreover, as Phillips shows us, there may be restitution. If a person goes to confession, they may be told restore it. And that's what happened, of course, in the people in Phillips when Father Coolman got the jewellery. I'm reminded of an old parish priest in our part of the country again, who after hearing a particular farmer's confession, and while there was a big line outside the confession box and the farmer had left and was walking down the church, the priest opened the door and shouted after him, "Be sure and give back the shovel." I wonder, was he excommunicated? Finally, the greatest policy argument of all, of course, is that it promotes freedom of one and practice of one's religion. I'm nearly finished, and I'm conscious that I'm exceeding the time. Two further points I want to mention. First of all, in Mullen versus the United States, in the federal law, once this issue came before the federal courts in 1959, this was a case where a woman was accused of cruelty and torture because she had gone off drinking and tying her children to the leg of the table, or chaining them to the leg of the table, and she was prosecuted for it. And she had come to the priest and told him her sins. And the federal law had to decide whether it existed or not. Now, they avoided the constitutional issues, but they determined it. It was determined by Fahey J. in relation to Rule 26 of the Federal Rules on Criminal Procedure adopted in 1948, where there is a provision which says the admission of evidence and the competence and privileges of witnesses shall be governed, except when an act of Congress or these rules provide otherwise, by the principles of common law as they may be interpreted by the courts of the United States in the light of reason and experience. So the federal courts quickly and smartly took refuge in a procedural rule and said, yes, we're going to exclude it under the privilege. One of the few cases that was cited in that case was Cook versus Cara. Now, it was fairly swiftly dealt with, and the court had appointed a lawyer to research some of the case law, and this was one of the 10 cases that appears in the end. As Professor Ryan said earlier on, there's a proposal in Ireland to introduce a statute of compulsory disclosure. This is in the wake of the child abuse scandals in Ireland, where the rules of the Catholic Church have come under scrutiny, as well as the confessional secrecy. And in it, in the lead up to it, as Professor Ryan said, Alan Shatter, the minister, said that he was not going to make any exception for the confessional privilege. In fact, that bill has become an act since in the last couple of months. But there is a provision in it which says the obligation to report is subject to any defences that exist in common law for criminal cases. Now, one can interpret that as saying there's a saver clause for confessional privilege or the sacerdotal privilege. But it only applies, as far as I can see, to criminal matters. In other words, if someone goes to a priest and says, I murdered the man, then the priest cannot hide behind a privilege. Sorry, he can hide behind the privilege. But it doesn't apply to non-criminal matters, as far as I can see in the statute. Now, the case of Cook versus Cara, paternity suit was not a criminal matter. The family law matter in ER and JR was not a criminal matter. So that seems to have slipped in unknown to people. I haven't seen it debated, I haven't seen anyone raise it, but it seems to have slipped into law now. And if that is law, then Cook and Cara may be challenged again under this Act. And if it is challenged under this Act, I have no doubt that lawyers would do well to read the People and Phillips and to raise another argument, namely the protection and practice of my religion. Now that's all I want to say, because I know we're under pressure here and we want to leave some questions and answers for other European matters. Finally, just let me say this exhibit number 1 here, the confessional box, the confession box. This is a public house in Marlborough Street in Dublin. As I've admitted or said, I'm chairman of the Abbey Theatre. This is within about 200 yards of the Abbey Theatre. And those of you that are moved to go to the Abbey Theatre in Dublin can avail of the opportunity of making your confession in this pub. It's a historic pub, and it's interesting because there's 2 or 3 plaques on it. It was where Don Busico's father was born, but in more recent times, it was used. It's next to the Pro Cathedral, and there was a lot of willing priests who sympathized with Republicans in the bad old days, and when they were excommunicated, some of these sympathetic priests used to go to a small room at the back of this pub and hear confessions of public Republicans who weren't received into the main Pro-Cathedral. It's an interesting backdrop to the whole argument. Finally, I just want to say one thing, and I'd ask Professor Bryan if he has something to say on this. The nature of confession, I mean, it's formal confession that I grew up with in Ireland, where you went into a box and the door slid by and the priest said, "Tell me your sins." That has changed dramatically, as has been said, in Ireland now, because none of the young people are going to this kind of confession. And the Church has responded by introducing the Sacrament of Reconciliation. Now, the Sacrament of Reconciliation, we're told, is the same as confession, except that it happens a couple of times a year, at Easter time and at Christmas time, and all the Church are told that you can now approach the altar, and there'll be a line of priests, and you can go up and tell the priests whatever you like, as much or as little detail as you like, and ask for forgiveness, and it will be given. So I wonder if what we're talking about here is, something that's going to vanish. That if I am a political refugee, if I am a murderer, tomorrow I just wait for this community confession. I go up, approach the altar, and whisper to the priest, "I have sinned and I'm sorry," and he gives me an absolution. End of story. In the old days, you had to be a lot more specific. There was a lot more interrogatories focused on you, dependent on the priest that you faced. But maybe it's not a problem at all for any criminals now that want to have it both ways. Thank you.